Good morning, everyone. It's 11:01, so I think we're going to get it started. And even if more people come in, that's not a problem. We want to welcome you to our presentation and virtual roundtable discussion on when off-duty conduct goes off-slide. My name is Dominique Fontaine. I'm a labor and employment partner at McInnes Cooper, and I will be presenting today alongside my colleague, Mallory Adams, who is a labor and employment lawyer at McInnes Cooper too. So I'll just take a minute to discuss some housekeeping items. All the mics will be muted during the session. However, you can, of course, contribute to the discussion by sending us your questions via the question text box, and we will address some questions we left some time in at the end of our presentation. And to ask a question, you'll find that feature on the right side of your screen. And we will try to get to as many questions as we can. However, if we're unable to answer your question, we encourage you to reach out to a lawyer in your region after our session if we haven't had the time to answer the question that you have. It's a real pleasure to see so many of you in attendance today. And I say this with every webinar that we do, but when we try to come up with subjects for these monthly webinars, we always kind of reflect and we ask ourselves, what type of questions are clients asking us? What is on our client's mind? What's making the news in the last couple of months? And if we go to the next slide, what we had an internal meeting and we kind of looked at the type of subjects that could be of interest. And we noticed that prior attendees to these webinars had advised us that off-duty conduct was a topic that they were interested to hear about. And obviously that includes the use of social media off-duty. That's becoming more and more of an issue for employers. And the fundamental question that a lot of our questions of our clients are asking us, and that is making the news in different contexts, is whether and how an employer can restrict what their employees do on their off time. So I'll just note here, I think it's important that we note that we're not talking about an employee's use of employer's account in the context of their employment. We're really talking about employees who are off duty and who use social media while being off duty. At what point can an employer get involved and impose discipline? And we put the slide here that says the new water cooler. So what we've been seeing is that employees tend to vent about employers and their colleagues online. And that's perhaps a discussion, perhaps prior to COVID, but was more of a discussion that would have happened between colleagues around the water cooler. But these types of conversations seem to be finding their ways to social media. We have employees who do not necessarily take the appropriate route to resolve issues that they have in the workplace, that we have employees that resort to public venting. So people and including employees, are feeling more and more entitled to vent publicly. And people are trigger happy on social media. And people know that, that posts can really get a reaction from the public at no cost, and even from the employer at no cost. And when people post online, there's always this perception of anonymity. And it's quite easier to talk negatively about someone, about a colleague, about an employer behind a screen than it is to do it face to face. So we see more of that perception where people don't hesitate to use social media. There's also this interesting whole concept of having the freedom of speech, and many employees believe that employers, can't restrict what they say on social media because they have this charter protected right of freedom of speech. And it's not the case. And I will talk about freedom of speech and how that concept comes into play with off-duty conduct in the context of this presentation. And why is it important for employers to be aware of that, of this issue? I think that public shaming can have a real impact on a business, and we see it all the time in the news. So I think that it is dangerous, and it's another reason, on top of managing your workplace, but it's another reason why I think employers need to be aware of what they can and cannot do in terms of managing off-duty conduct. So if we go to the next slide, I alluded to the fact that it's a hot subject in the media. So this is just a couple of examples, and I'll just talk briefly about two of these examples. The first one is during the trucker convoy during COVID, there were several examples in the news of employees who were taking company vehicles, company trucks, or that identify or had the company logo identifying on their jackets or on their truck. There's no case law that came out of that to my knowledge, but this would be considered off-duty conduct. And there's a couple of articles that I was reading through where the employer said, this person is going to get fired. They said it right in the news. So as it currently stands, I don't think that there's any case law on it, but it's an example of off-duty conduct. And another interesting case that was in the news, I think it's last week, is the case of an education assistant in BC who set up an OnlyFans account, and she was asked to shut it down by her employer. So OnlyFans, for those of you on the call that don't know what that is, it's a paid subscription site known for custom pornography. And she explained to the media that she was a single mom, and she did that as a side gig to make ends meet. And she posted several pictures of herself on Instagram, encouraging people to register to her OnlyFans. And after receiving complaints, the school board demanded to her that she shut down her adult content accounts on social media. And the school board deemed it inappropriate in light of her role as a public servant, like helping special needs students. It's an ongoing issue. She went to the media on it. The school board told her she can't talk publicly about it. And my understanding from reading that news article is that there's an investigation going on. Of course, the union came publicly and told the media that they would protect her all the way, and they supported her. So that to me, it's a perfect example of off-duty conduct, including a public servant. And we can fully anticipate that we will see more about this story, and perhaps it will go to arbitration. And if so, well, we'll provide you an update when that decision comes out. So if we go to the next slide, I just wanted to, keeping these examples in mind, we're going to turn to the law as it relates to off-duty conduct. So I think it's important for everyone to remember that as a general rule at law, employers cannot control their employees' conduct outside of working hours. However, like any other legal issues, there are some exceptions. So we talk from the premise that we start from that premise that employers can't control what their employees do on their off times, and then we look at those exceptions. So in the next slide, the employer's right to discipline employees for their off-duty conduct as an exception has been recognized for more than 45 years. It's been long recognized at law, and obviously the case law has developed for that to apply to the social media world. And really, at the root of it, the employer's right to discipline or discharge an employee based on the off-duty conduct depends on the effect that the conduct has on the operations of the workplace. To be able to discipline or discharge an employee for off-duty conduct, there needs to be a necessary link between the conduct and the workplace, and the conduct needs to have a detrimental impact on the employer's business. So there needs to be that nexus. That's the key factor when we talk about off-duty conduct. So in the next slide, you know, the question, it's always the question when we deal with discipline, does the conduct warrant discipline? So if we go to the slide after that, just as a general rule, and I think that everyone on the call would know this, an employer can only discipline an employee for misconduct with just and reasonable cause. So that same test applies when we're dealing with off-duty conduct. So an employee's off-duty conduct, and that's whether or not it's unionized or not unionized, it can be cause for discipline. And if we go to the next slide, that's the test. So that's the test for off-duty conduct. As I said previously, the employer's right to discipline depends on the effect the conduct has on the operations of the workplace. So these 5 factors that we see here, we call them the Millhaven factors. These were developed by an arbitrator in 1967, before social media, you know, was alive or was a thing. But these still apply to today to off-duty conduct, including the use of social media. So these, in order to be able to justify discipline of an employee, the employer needs to show any of these factors. So it's not all of these factors, it's any of these factors. The first factor is, can the employer show that the employee's conduct harms the employer's reputation or product? And that's one that we see often, and that's one that I think we see a lot of in terms of the use of social media. The second factor is whether the employee's behavior renders the employee unable to perform the duties with satisfaction. The third one is whether the employee's behavior leads to refusal, reluctance, or inability of the other employees to work with them. The fourth is whether the employee has been guilty of a serious breach of the criminal code, rendering her conduct injurious to the general reputation of the employer and the employees. And the fifth is whether the employee's conduct places difficulty in the way of the employer's ability to properly carry out its function. So there's a consensus at law that any of these 5 factors can establish that nexus that I was talking about between the employee's conduct and the resulting harm of the employer's interest. In terms of social media, there's we see that often. There's an argument that could be made, you know, by the employee or the union that they have a right to privacy, like employees have a right to privacy doing off-duty conduct and using social media. However, arbitrators and courts have recognized that once an employee uses social media to make comments or to give an opinion, there's an assumption at law that the employee knew the potential for virtually worldwide access to the post. So that argument of an expectation of privacy, I think, would not go far on behalf of the employee or the union. So if Mallory, if you just click on the next slide, so the main basis on which social media use typically constitute misconducts worthy of discipline. And what we've seen with clients is situations where the posts or the comments would damage the reputation of the employer, where there's leaking of the employer's confidential and proprietary information, when there's cyberbullying and harassment, and where there's insubordination. So if you go to the next slide, the essential question to determine, you know, whether or not that nexus is there in light of the Millhaven factors that I was talking about earlier is whether a reasonable and fair-minded member of the public would consider that the employee's employment would be damaged to the point that the employment relationship is no longer tenable. And I want to make just a quick note about that question, just to note that the application of that question will depend on the employee's occupation. It's not all employees that are held to the same standard. So a higher standard may apply to public servants, to those employees that serve the public. And there's all sorts of case law out there that talks about, or that suggests that when a public servant is the subject inquiry of off-duty conduct, the reputation of the employers is more easily met, and it forms the focus of the analysis. Public servants would be expected to function with a heightened level of respect and dignity, even off-duty. Of course, other factors to consider whether an employee's social media use is worthy of discipline would be the seriousness or the inappropriateness of the social media use, and the overall effect on the reputation of the business. The next slide talks about freedom of expression. And we actually got a question before the seminar on freedom of expression, and it's something that comes up quite often because, as I said earlier, employees will say, well, what about my freedom of expression? I am free to express my political beliefs online, and you cannot restrict that. So if we just back up, like the charter guarantees individuals the freedom of thought, belief, opinion, expression, peaceful assembly, including for the purpose of expressing their thoughts, beliefs, and opinions. However, the charter applies to protect Canadians from government actions, and that includes government as the employer. But the charter would not apply to private interactions between employees, nor would it apply to employers in the private sector. So we need to understand that distinction, that it doesn't necessarily apply at all times to the employment relationship, and that it does not apply for the employment relationship in the private sector. Nor does the charter protect employees against employment consequences. Of course, as I said, the employer is a government entity. And the next slide. So even when the employer is a government entity, and the charter does apply to the to the employment relationship, infringement on charter protected rights can still be reasonable and justifiable at law. And I just have two examples that I can quickly talk about. There's an arbitration case from 1985 involving the hospital and healthcare workers, and there was 81 employees who were absent from work without prior permission to attend a political protest, and discipline was issued on these 81 employees, and the union grieved. So the union argued that they had a right to protest in accordance with the charter. And the arbitrator decided that the employees' unauthorized leaves did constitute cause for discipline. And he recognized that although they were exercising their charter-protected freedoms to attend the protest, and the employer's discipline did infringe on those freedoms, it was a reasonable limitation under the charter because it did not deny the freedom of expression entirely. What it did was that it limited them to the extent that they couldn't engage in political protest during the specific times that they were required to attend work. So that was an interesting, an interesting case. In another case from Ontario from 2002, there was a termination of a teacher for off-duty conduct. And the teacher was terminated for his participation in conferences and meetings that were sponsored by individuals who advocated and supported white supremacist and anti-Semitic views. And the teacher never actually expressed racist views in the classrooms, but the employer viewed that his participation in these outside organizations were incompatible with his role as a teacher. the arbitrator determined that the protections of the charter applied, but agreed with the employer that the restrictions to the teacher's freedom of speech was justified under Section 1 of the Charter. And in doing so, the arbitrator explained that there's a line between controversial political expression and like racist and hateful speech. And in this case, the line had been crossed such that the termination was justified. In terms of the next step, and then I'll let Mallory talk after that. So the next slide talks about, what type of discipline is appropriate. Of course, discipline needs to be proportional to the harm that is caused to the employer's reputation or interest. And really, it's the same type of questions that we should be asking ourselves as employers on what type of discipline is appropriate. So you look at all these factors, the nature, the extent of the conduct, the length of the service of the employee, the previous disciplinary record, whether the incident was isolated. And just in terms of whether the incident was isolated, we often say that for a termination to be based on a single incident, like it needs to be a very bad incident, right? It needs to be severe. I was thinking in French. It needs to be a severe incident. In terms of social media use, understanding that it provides access to, like, if someone posts something and it provides access to the public and that it stays online. I think there's more cases where a single incident of posting online could potentially justify a termination because of how it's publicly accessible. So all of these factors would still need to be considered to determine what is the appropriate discipline. Oftentimes, we do recommend, when there's clients that come to us with issues of off-duty conduct relating to social media, we do encourage employees to conduct an investigation and talk to the employee to get their version of the facts and understand, what prompted that, etc. And a lot of times we don't see any remorse and we say, no, I was justified, blah, blah, blah. And that can help ultimately in the decision to terminate. So it depends on the facts, but we will at times recommend doing an internal investigation into the comments before rendering discipline. Mallory, if you want to continue, I'll be back after.
Perfect. Thank you very much, Dominique. So I think we all have a really good understanding of the law in this area now. So we'd like to turn now to some case studies. So I'd like to get everyone's opinion on some social media off-duty conduct and whether you think it would warrant discipline or not. And then we'll kind of talk about what happened and why, and we'll go through those. So the first scenario that we have, we want to know, in your opinion, and we'll go to the poll in just a moment, but do you think that these off-duty tweets warrant discipline? So the first of these was that an employee alleged that there was sexual assault in the workplace and that the employer was silencing women with threats and retaliation. The second sort of tweet was that the employee posted a screenshot of a group chat where it was allegedly between two colleagues in her workplace, where one said, "Regent kids were given a tour of a police station," and the other replied, "Well, shouldn't the tour guide just stop at the cells and let them know most won't make it past there?" And following up on this, the employee alleged racism in the employer's operations. And for any who don't know, this is referring to a particularly marginalized and typically lower income region in Toronto. And then she also named a specific colleague on social media and alleged that she received peanuts and a gag order to stay silent about violent abuse from a male colleague. And finally, she posted a group text where colleagues discussed an intimate part of an employee's body. So we're going to put a poll up on the screen now for you to answer about whether or not you feel these tweets warrant discipline. So it's simple, yes or no. I'll just give you a a bit of time to respond. Okay, so we're going to share those results, I believe. So do these turns. So we have 88% saying yes and 12% saying no. So fair enough. I mean, that's, I think, fair enough. So the facts and what actually happened in this case are that this was actually a Toronto Police Services constable. And it was found in a decision that came out on May 2nd of this year that she must resign within 7 days or she would be fired. She was found guilty of 8 counts of misconduct, according to the police tribunal decision. And in this case, as we just discussed, her tweets alleged racism and sexual harassment within inside the service. Additionally, there were some other pieces of sort of off-duty conduct. She had refused to leave the property of another officer, and she had refused to take part in the internal investigation, which the police service had launched in response to her allegations of sexual harassment and racism. Now, she indicated that she did not do that because of her mental health, and saying that she said she had PTSD and she was unable to take part in that process. But the decision maker ultimately found that the PTSD would not have impacted her conduct, and so that was sort of the reason for the finding as it was. And so let's go a little bit. So this is the case, and we can obviously provide the link to the CBC article. Now, the hearing officer's decision is not, at least from what we can find, is not public at this stage. But if it does become public, obviously we'll update this. But ultimately, what was happening, and this is kind of the case of reputational harm that Dominique was talking about. It was found that Constable Zarabi Majid's tweets alleging racism and sexual harassment inside the service, along with her refusal to leave the property of the officer and her refusal to take part in the internal investigation, including the fact that she actually didn't attend this specific hearing, were all violations of the Code of Conduct and the Police Services Act. And they said, taking into consideration all of this, the nature of the acts and the seriousness of the misconduct, it just demonstrated an inability to reform on her part. And so that was why the decision was made for her to either resign or have her employment terminated. Now, this actually all started approximately 3 years ago when the constable brought the toxic workplace instances to the attention of CBC's fitness state, basically saying that the environment was so toxic, you're just constantly trying to survive. She alleged that she was kissed without her consent, that male officers asked her to describe the bodies of female suspects that she had searched, that she had found pornographic magazines lying around the workplace, and she used this all as part of a claim that she brought before the Human Rights Tribunal of Ontario. Now, despite all of this, really what it came down to was that she had caused irreparable damage to the force. So rather than just taking her complaints up the chain of command, as would have been appropriate, she took them to social media through her tweets. And it was found that what she was attempting to do was really to sort of tarnish the reputation of the police service, the police force, and also the mayor, John Tory. And that was sort of the impetus for these, and that's really why, it came down to the decision that it came down to. And this is an interesting case because, and we'll see in the next case study, oftentimes we see people doing things that are sort of allegedly discriminatory or harassing, where in this case she was complaining of it. Now, her counsel attempted to say that this was whistleblowing, but again, it really came down to the fact that she didn't follow the appropriate chain of command. She didn't participate in the investigation that was undertaken when her allegations were sort of brought through the police services, and she took to social media instead. As Dominique said, she's kind of using this social media as the sort of new water cooler rather than going to her appropriate authorities and keeping it within the organization. So we'll do another case study, and we'll get your opinion again on this. And I'll ask you, and I'll sort of talk briefly about these tweets as well, and then ask you the same question. So here you'll see on your screen 3 tweets by 2 different individuals. I'm not going to read them. You can read them for yourselves. I just find them to be a little bit distasteful, to say the least. But I will draw your attention just a couple things. So if you look closely at the top 2, you'll see that it's the same individual, and you'll see in his photo he's actually wearing his uniform. And then in the bottom, the Twitter handle is basefire3680, both of which we'll talk about further came to be important. But we'll throw up a poll now, and again, do these off-duty tweets warrant discipline? So you can simply answer yes or no, and we'll give you a moment to do that. Okay, fantastic. So 75% are saying yes, and 25% are saying no. Again, makes sense. It's not definitely not a cut and dry issue. So these are actually tweets made by Toronto City firefighters, and this was a case from 2014. And in this case, the fire department had presented an internal report to the city outlining its plan to increase workforce diversity, particularly amongst women and racially diverse personnel, which were woefully lacking in the Toronto firefighting service at that time. Following that report to the city, the National Post reproduced these tweets and identified the employer and the employees. Kind of as is the Toronto City firefighting service really ready for this diversity, right? So at the time, the employer had several policies setting out firefighters' uniforms and when and where they could use their uniforms. They had a discrimination policy, a public conduct policy, and a personal use of social media guideline, which stated that, employers were free to use their social media for personal purposes, but some policies, including human rights and anti-harassment policy, would apply to off-duty conduct. And just reminded them that they could be identified as employees by posting their names, their place of work, their photos, or other similar content. So the employer actually ended up terminating the employment of both Matt Bowman and LaJuan Edwards based on these tweets and the investigations following therefrom. So in this case, they did do investigations, and they terminated their employment on the basis that it violated the internal policies and guidelines, and on the fact that these tweets had caused reputational harm. So both employees grieved, and it's interesting, both had been employed for approximately 2 years and had clean records, so no prior discipline. In Bowman's case, as I said, his uniform was clearly identifiable in his profile picture. And then with respect to Edwards, the arbitrator found that the sort of fire in his Twitter handle was fairly indicative of the fact that he was a firefighter. Bowman crafted a very eloquent apology, which in his help with the union, but in the results, the arbitrator found that it was not sincere. Edwards offered no such apology. Both indicated they didn't understand Twitter. They thought in some cases that they are having private conversations, but again, you look at the Twitter policies, you look what Twitter is. Both arbitrators in the decision found that was kind of irrelevant. Of course, it's a public space, and of course that people are going to see these tweets. Bowman was incredibly dishonest in the investigation, whereas Edwards was forthcoming. Bowman had been given ample opportunities to provide any other sort of previous tweets. Was there a history of this? Was there anything else that the service should know about? And he denied it, and it came to light that this was just the tip of the iceberg for Mr. Bowman. I mean, he had made a significant number of violent, discriminatory tweets on the basis of sex, race, ability, among other things. So in the results, it was found that Bowman's dismissal was upheld, and this was based on the fact that he was very unlikely to reform. While he did undertake some sensitivity training after the fact, after his dismissal, the arbitrator just concluded that he created a poisoned work environment. He had fundamentally breached like the human rights and anti-harassment policies that applied to off-duty conduct. And there was no bringing him back. It really was about his role as a firefighter. And he was to be entrusted with entering people's homes and providing service in their time of need. And, if a reasonable person viewing these tweets, like an expectant mother or someone with a disability viewed these tweets, would they welcome him into their home? And the arbitrator decided no, absolutely not. And so the termination was upheld. With respect to Edwards, however, the tweets that were published were one of a few. Now, the employer did cite a couple other tweets, but they weren't really rising to the same level. They weren't as serious. And in some cases, he used negative language, but was actually to sort of tell Bowman, in fact, not to be racist. So it was different. He was not creating the same kind of poison work environment. He was not causing the same type of reputational harm. And so in his case, even though it was similar conduct, it did just not amount to the same thing. And his termination was substituted for a 3-day suspension. So it's an interesting case where we can see similar conduct, but sort of the factors that Dominique was talking about really coming into play when determining whether a termination is warranted in the circumstances. So we're actually going to do a third case study. So in this one, we'll ask in a moment whether, again, does the off-duty conduct warrant discipline? So in this case, slightly different facts. We actually have a union rep, and they were inserting sort of edgy and aggressive critical comments onto a document with red pen and highlighter. And the document was a letter from a government employee to staff, which was disseminated to about 1,000 people. He posted it, the marked up letter, on personal Twitter and social media accounts that did not actually identify him as a union representative. And then when it came to the attention of the employer requested on 4 separate occasions that he remove the posts, and if he did not, that he would be subject to disciplinary action. So we'll throw up a poll now. And so, do you think that this off-duty conduct post warranted discipline? Simple yes or no again. So in this case, 74% yes and 26% no. And I think, again, pretty understandable numbers. This is a fairly nuanced one as well. So in this case, the gravor, as I said, was a union rep, but was a union executive as well. And this is actually a local case, the Nova Scotia Teachers Union in Cape Breton Regional Centre for Education. He was 16 years of service with no prior disciplinary record on his file. He was a union exec, he was the secretary treasurer, and he had been since 2017. And he was very active in both his local and provincial level union activities. He had posted on social media in the past very extensively, and the employer took no issue with this because he was posting in his capacity as a union member on issues of importance to the union. And in this case, however, what happened was that regional executive director issued a letter with respect to return to in-person learning protocols, which he marked up. And he indicated he did it to bring attention to occupational health and safety issues, whereas the employer took the position that, of course, it was inappropriate and inflammatory and caused to sort of shame the employer and the regional executive director. So in this case, The employer issued a 5-day suspension on several different grounds for the breach of confidentiality, because it was, in their opinion, the post was intended to bring shame to the regional executive director and to embarrass the employer, as well as undermine its authority and its ability to conduct its operations. So the arbitrator on the issue of breach of confidentiality, which is one of the areas that we see come up with respect to social media posts, they actually found that this was not a breach of confidentiality in this case. And that was because this letter was a template, and in this sort of slightly different variations was published to about 1,000 employees. So it wasn't actually intended to be a confidential document per se. So it's kind of important to note, like, what is the intent of the document when you're talking about confidentiality. In this case, the arbitrator also, with respect to the idea of like shaming the regional executive director and the employer, they noted that it was the griever's evidence that he had done this to bring attention to occupational health and safety issues and did not intend to embarrass or shame. The arbitrator found that while the griever's comments were edgy, they didn't actually cross the line into personal attacks. So it came down to, as I'm sure a lot of us know, union representatives have a heightened protection on their speech because they're in their role as union member or union reps. It's their job to bring their members' issues to focus, so they have to have a bit more of a heightened protection in the type of speech that they're allowed to engage in the workplace, right? They kind of skirt that line of insubordination sometimes, in the advance of aiming the sort of the causes of their membership. So in this case, the griever didn't identify himself as an NSCU rep. He said he was a member, but the arbitrator found, that the griever's failure to expressly identify himself was not fatal in this case, and that the protection was still afforded to him. He didn't fail to do this in a way that was like malicious or reckless. He didn't post anything that was malicious or recklessly false. So the post itself was not the issue, but then the union also brought up the charter argument as well. So this is one of those cases where, because it is a government actor as an employer, the charter may come into play. In this decision, they didn't delve too deeply into the charter, but said that, it may apply in the future. Here, the issue came down to the insubordination. The griever was asked to take down the post 4 times. The arbitrator found that was a reasonable direction. In light of COVID, in light of the fact that the employer is really just trying to get the message out about safe return to school, they were trying to manage a workforce, they were trying to manage an education system in a time of COVID and uncertainty and just kind of unprecedented times. They were completely sick of that phrase. But that in this case, it was insubordinate. So in the results, the griever was issued a 2.5-day suspension for the insubordination rather than for the post. Well, it was skirting the line, it didn't cross the line. So kind of an interesting nuance in this case. So the final, I'm sorry, I'm rushing through these. I'm mindful of our time. I want to get to your questions. So this is the last poll. This is the last case study. So we'll talk about it very briefly. In this case, there was an elected public school board trustee who posted negative comments and criticism on their personal Facebook account with respect to the employer's new policies as they related to school sexual orientation and gender identity materials and teaching that subject from primary to 12. Those posts attracted significant criticism and publicity, and then the union president was called upon to talk about that. He was also a member of the LGBT community, and in his interviews, he expressed opinions about the trustees' posts. So in this case, we have a kind of a 4-part question. Do you think there's any fallout from this conduct, or should be any fallout from this conduct? If so, yes for the trustee who initially made the posts, yes for the teacher and union president who came out in opposition to the trustee's position, yes for both, or no for either. So we'll post that now and give you a quick second to think about that. And Perfect. And understandably, very mixed here. So 2% say yes for the teacher, 36, I believe, like saying yes to the trustee, 47 at yes for both, and 13% at no for either. And so this is interesting. This is still an ongoing one. So in this case, not really in the employment context, but the trustee actually sued the teacher for defamation. The teacher has applied to have the defamation action dismissed under the BC Protection of Public Participation Act. It's kind of the anti-SLAPP legislation, or the anti-strategic lawsuits against public participation legislation, which allows for the early dismissal of these types of actions where they are part of like sort of the important public discourse. The first court actually dismissed the defamation action, concluding that the public interest in allowing the debate was greater than the public interest in allowing the defamation proceeding. The appeal court actually overturned that decision, and we should hear from the Supreme Court of Canada tomorrow on whether or not that defamation action will be allowed to proceed. So here the consequences are more to the teacher directly, although the trustee has argued, again, reputational harm in bringing the defamation action forward. So this is one that, could have also had implications for the union, as it was a teacher, but he's also acting in his capacity as union president. Could have had implications for the school board as well, or the school district. So it'll be interesting to see how the Supreme Court of Canada determines sort of what the sort of ground rules are for defamation suits and social media statements of this kind. So we'll stay tuned, and we'll be able to provide you an update hopefully the next little while on that one, but something just to think about, right, about where the line is and what employers can and can't sort of dictate with respect to their employees. And in this case, the individual is a union president as well. So I'm going to throw it back to Dominique.
Thanks, Mallory. Interesting cases, and for sure. And the firefighters one is a case that, we've talked about often because it's interesting facts, but it's a main case on the usage of Twitter for public servants and the firefighters. And it's a very interesting case, and no one ever wants to read the tweets out loud. It just makes us all feel too uncomfortable. And this is the last slide. I'm going to be quick, and then we can go to the questions if there are any questions. So what should you do, as an employer in terms of off-duty conduct? We always recommend to have a separate and distinct social media policy. It's not necessary to be able to discipline for off-duty conduct, but it certainly makes our job as lawyers easier if you have one and the employee has signed off on, and it prevents an employee from saying, I didn't know that I couldn't do this on my off time. So it's the safest approach would be to have, a code of conduct plus a separate and distinct social media policy. In terms of the scope of such a policy, it should apply to everyone in your workplace and should cover all of the company. And I think that thought needs to be put toward whether or not it should apply to contractors or others that may effectively, that could do things off duty that could reflect badly on your company, particularly if you have contractors that go on site, etc. And in that policy, I think it's important to clarify that the line between work and personal time isn't all necessarily distinct, and that employees are to govern themselves honestly, respectfully, and ethically in both capacities at all time. It's also important to emphasize that monitoring of public social media activity will occur, whether the employee is on or off duties, and encourage your employees to use privacy settings and control within their social media use, explaining that there is, in any event, no anonymity online. Employees have to understand, from the outset, I think that if that message is sent, that they understand that they are accountable for all of the content that they post online, that they could potentially be, the consequences for not being accountable for that, like discipline, that should be from the outset told to your employees, and perhaps it will prevent them to be as, trigger happy and to post online. So obviously, and we talk about policies and consistently enforcing policies. Policies will only be, relevant and applicable if they are consistently enforced. And it's no different for social media policies. So if we go to the next slide, Mallory, I think it should be the question slide. There is, so I'll get to the question and then I can talk about MC Legal Labs a little bit. So we had a question come in. Can this be related to regulated professionals in any way? So I guess, good question. There's two distinct aspects to this question, perhaps. First of all, in terms of being a regulated professional, the code of ethics of the professional association would be the starting point. And a complaint could be filed with the regulatory body. So in terms of if a complaint is filed for off-duty conduct by a regulated professional, then the professional association would, in my view, have every right to follow its complaints process and investigate into this complaint and the social media use. That's usually separate from the employment relationship. In terms of having a regulated professional as an employee, and we alluded to that earlier, that in our view, these individuals would be held to a higher standard of scrutiny, even with off-duty conduct. And for example, I had a case a couple years ago involving a nurse who had made racist comments online regarding First Nations, and we had analyzed this whole situation, and the fact that she was a nurse and there was case law on that she was serving the public was a very, very relevant factor to the analysis. So being quick answer, yes, it can be related to regulated professionals 100%, and the fact that you are dealing with a regulated professional would heighten that scrutiny. Okay, there's another question that came in. Where is the line on what an employer can do when an employee is saying and posting things about the company online? I guess, first of all, I think that if you have an employee who is posting things about the company online, I would address it. 100%, I would start by addressing it with the employee and telling them why it's not acceptable and asking the employee to start. I think that's the starting point. But the line at law and as to whether or not that person can be disciplined is that nexus that we talked about, whether or not there's reputational, whether or not that causes reputational harm to the employer and whether or not that employer can prove it. So it's a question of whether or not the employer can prove any of those 5 factors that I outlined earlier from the 1967 case. Those factors are still alive. So that would be the line, is whether or not there's a nexus and it affects the reputation of the employer. But and I alluded to that a little earlier, like when we deal with these types of situations, I think the first thing would be to ask the employee to come in and explain themselves and ask them to remove the posts, etc. And oftentimes in the context of that investigation, you're going to see where their frame of mind is and whether or not there's remorse, etc., which will have an impact if you choose to issue discipline on that. Okay, we have another question here. And I think it's the last one that has come in. We still have a little bit of time if anyone has additional questions, but there's the last one here. What are controversial issues and why are individuals not entitled to their related personal views? I would say that employees are entitled to their related personal views on controversial issues, as long as there's no nexus to the employment relationship, and it doesn't affect the employer's reputation. So if there's none, then if it doesn't affect the reputation of the employer and there's no nexus, then none of these factors under Millhaven will be met. So that, I think, is where the line is. And I talked about the charter a little bit. So for those employees that their employer are government entities, if the charter applies, and as Mallory, you alluded to the fact that the charter was, invoked in your case, but it wasn't necessarily applicable. We don't see a lot of cases involving the charter in the labor world, and I talked about 2 cases. But if the charter apply, then the question is whether or not it's a controversial political expression versus hateful speech and racist comments, because there's a line between the two, and the charter wouldn't allow someone to post hateful speech or racist comments. So I think there's a line there too that should be considered, but of course that line is always a factual determination. So it's that's why if you have an issue like that, I think it's safe to call your lawyer to get an opinion on whether or not the line has been crossed. And that leads me to say thank you to everyone that participated this morning. And there was a slide there about a service that we offer at MC Legal Labs. So what it is, it's training workshops that are led by our labor and employment team to support continuous learning of your people. And we provide, practical skills to mitigate and manage legal risks within your organization. So if there is any interest in MC Legal Labs, we're here to provide you with additional information. Of course, if you have additional questions that come up, regarding our presentation, feel free to reach out to either me or Mallory. And I am wishing you a good rest of your day, and thanks again for coming.